Dear students, already I have spoken to you 2 times regarding Indian Constitution, how the Indian Constitution came into existence, and some important parts of Indian Constitution, particularly Part 3 of the Indian Constitution and Part 4, which deal with the important aspects like fundamental rights and fundamental duties. Today, we will have a discussion that Indian Constitution, such a big constitution, whether it has got a provision for amendment or not, this is a question to many people. Of course, there is a provision in our constitution to amend it. Article 368 of the Indian Constitution, as you know, there are 395 articles in our constitution. Article 368 deals with the amendment of the constitution, how the constitution can be amended, the procedure of amending the constitution. The procedure is that two-third majority of the parliament, any house, whether it is an upper house or a lower house, Lok Sabha or Rajya Sabha, the proposal for amendment of the constitution can be made either house, either in the Lok Sabha or in the Rajya Sabha. Two-third members should give a request for the speaker for the amendment, the matter of amendment. Already, when we accepted the constitution in the year 1950 on 26 January, immediately in June 1951, the first amendment was made to the constitution. So that way, as on today, we have more than 120 amendments to our constitution. So I am not going to discuss all 120 amendments, but some important amendments have been made. And let us have a discussion regarding those important amendments. For example, 42nd amendment, which was done in the year 1976 during emergency. During emergency, Indira Gandhi was all in all, and she made many changes, many amendments in the constitution as she likes. She liked many things to be changed, and for example, number 1, the words secular and socialist, integrity, these words were added in the preamble. Earlier in our preamble, it was a democratic republic. In the preamble, Dr. Baba Sahib Ambedkar's chairmanship, the constitution which was written, in the preamble it was only democratic republic. The word secular and socialistic, these two words particularly have been included in the constitution as one of the amendments of the 1976 in the 42nd amendment. Then the directive principles also were given importance than fundamental rights. Directive principles have been accepted from the Irish constitution, but there was a confusion between directive principles and the fundamental rights. Fundamental rights are connected to individual. Directive principles are the direction for the state governments, how to act for the welfare of the people. So many people have misunderstood the directive principles and the fundamental rights contrary to each other. They are not contrary to each other. The fundamental rights safeguard the interest of the individual, whereas the directive principles, they safeguard the common public. And that amendment also was made, and fundamental duties also were added. In the last speech I have told you some 10-11 fundamental duties have been included, including one more duty added in 2002, that a compulsory education should be given to the children from age 6 to 14. It is a government responsibility as well as the responsibility of the parents. These fundamental rights were added, 10 fundamental rights were added in 76 in the 42nd Amendment. And one more amendment was, Parliament was given a supreme powers to take any decision. Setting aside Supreme Court and President, Parliament was given supreme powers in this 42nd Amendment of 1976. And education, which was a state responsibility earlier, but education was included in the concurrent list. Concurrent list means it is the responsibility of both state government as well as central government. Some responsibilities are with the state, some are with the central government. For example, railway, external affairs, defense, all these things are dealt by the central government. The education, sale tax, social reforms, all these things are the responsibility of the state government. Education also is the responsibility of state government, but education is included in the concurrent list also. Central government also can interfere in the education department. And the one most disastrous amendment was made was the tenure of Lok Sabha elected people was 5 years only. Our constitution writers have fixed the period of Lok Sabha members, MPs, was 5 years only. But during emergency and the tenure of Lok Sabha members, MPs, elected for lower house, that also was made 6 years. Since the period of Rajya Sabha members is 6 years, there is a reason for making 6 years. Rajya Sabha is a permanent body of the central government. And therefore, every 2 years, 1/3 members retire and new members are elected. To adjust for that, Rajya Sabha members' periods and council members in the state is made 6 years. But Indira Gandhi thought that it should be made 6 years also. Lok Sabha also should be for a 6 years period. Of course, this 6 years was immediately reverted when the Morarji government came. And coming to 44th Amendment, in 76, this 42nd Amendment, all these which I explained have been amended. In 44th Amendment, in the year 1978, when Indira Gandhi lost election, Morarji Desai became a Prime Minister. Janata Dal or Janata government came to power. What they did was, all the errors committed in the 42nd Amendment, the errors means making the Lok Sabha period 6 years and Parliament making a supreme power, all these all have been reverted, set right. And second one, Article 31, which is a right to property. This right to property, which was given by the constitution writers in the beginning only, and this Article 31 relating to property was scrapped because many black marketeers, government officials, they earn lot of money, 100 times their legal income. So this made the government very alert. Corruption was going on rampantly and black marketing was going on rampantly, and because of this black money they were trying to control the government also. The government thought in 1978 in the 44th amendment, and this article 32 was scratched. Anybody makes a property, government has got right to make an inquiry on that, how he acquired that much of property. And declaration of emergency. For declaration of emergency, there are three types of emergency. One is external emergency, another is the internal emergency, third one is the financial emergency. The internal emergency, there was no valid reason for declaring emergency as internal emergency. Indira Gandhi did in 1976. There is a disturbance in the country, that's why emergency has been declared. So this point also was thought very seriously, and for declaring any emergency, the approval of Council of Central Government, Council of Ministers is required. In 1976, Indira Gandhi declared emergency only with the signature of President. Then President, who was almost a puppet, rubber stamp in the hands of Indira Gandhi, and that was removed. And to declare internal emergency or external emergency or a financial emergency, the approval by the cabinet is very essential. And another is regarding president rule. The central government was declaring president rule in any state which it wants to remove the government from the state. Any government which is not cooperative to central government, they declared central president rule in that country. But that was, the president rule can be declared for 1 year. The period for president rule was 1 year, and after 1 year election can be held in that state. But there also changes were made. The president rule can be at the maximum only up to 6 months, not 1 year. This change also was made. And declaring national emergency also, internal emergency was declared because of internal disturbances. Giving the reason there is an internal disturbance. It is very vague. But the change was made that internal armed rebellion, if there is any internal armed rebellion, then only internal emergency can be declared. Not simply by saying there is internal disturbance. There should be internal armed rebellion, then only internal emergency can be declared. This change also was made in the 44th Amendment. The government's hands are tied there. The people in the power should not do anything, everything that they liked. There is a control over the government also. And coming to 73rd Amendment, it is also one of the important amendments done in the year 1993. A Panchayat Raj bill was passed. First of all, it was introduced in Rajasthan and then to rest of the India. The interest or intention of declaring the Panchayat Raj, the interest was giving more powers to the local self-governments like panchayats. Panchayats are made powerful because the money sanctioned by the state governments was coming to district and then to taluka and then it was distributed to village panchayat. But there was a lot of leakage in these steps. But panchayat will receive directly the financial assistance and they enjoy some democracy also. Panchayats also are given some democracy that they can do something good to their own village. What they feel that it is good to the village, they can do it without consulting anybody in the panchayat they can declare themselves. And in the 74th amendment, it also was done in 1993 only. And establishing municipalities also. Big cities, they have their administration, local administration through municipalities, corporation and all that. And for them also, financial powers and tenure is given for their urban development. So these are done in 1993. And in 2002, 86th amendment was done. This is regarding providing compulsory education to the age group between 6 and 14 is the responsibility of the state government. This amendment was made. Providing compulsory education to all the youngsters who are between 6 and 14 years. This is done in the 86th amendment in the year 2002. And 91st amendment in 2003 was made. It strengthens the anti-defection bill. By 2003, there was a rule of ayaram gayarams. People were changing their parties like anything. There was no restriction on them. There was no restriction on ministry, chief minister or central prime minister. They were expanding the ministry like anything, providing a chance to their own people very liberally. And in 2003, this amendment was made, the 91st amendment, that the anti-defection bill was brought. Means, at least 1/3 people of that party, if they want to change the party, they can change. Otherwise, 1 or 2 people cannot change. If they want to change the party, their membership will be invalid. This rule was made or amendment was made to the constitution, and then the people jumping from one party to another stopped. The one more restriction was that the ministry should not be more than 15% of the elected members. There are members elected for the state assembly, members are elected for the Lok Sabha, central government, and the ministry of the central government and the state government should not be more than 15% of the elected people. Earlier there were 20%, 25%, even 30% also people were given the ministry. And the expenditure of ministry was very huge. It was like protecting a white elephant. That's why this restriction was put on these rulers, that a ministry should not be more than 15% of the elected people. This is done in 203, and in 213, 117th amendment was made. This is giving a development provision for the backward areas. For example, Hyderabad, Karnataka was regarded as a very backward area. Article 370 we have heard. Article 370 was giving a special provisions to Kashmir only. But Article 371(3), subsection 3, a special concession should be given to the backward area for development. For example, Gulbarga. So in this way, these are the important amendments have taken place right from 1951 to till today. I have discussed only regarding the important amendments. There are many amendments which have taken place. As told that nearly 120 amendments have taken place already, and lot of amendments have been made to our constitution, and there should be restriction for amendments also. then only we can have a rule of law. Anyway, so you go through all the amendments for what they have been made, and I have just spoken regarding important amendments only. And when we meet in the regular class, we can discuss whatever doubts you have, whatever amendments you want to know, that we can have a discussion in the regular class. Mostly our classes may commence from 1st November onwards. So whatever notes are given to you, whatever lessons you have heard, prepare notes on that, fair notes, and while coming to the college, bring them and show it to your concerned teachers. Mostly in the first week of November, we may start the regular classes. Thank you.